live stream, so bear with me 1 second.
Tara, are you okay? Can you remain
I'm
there?
back. I thought that they were kicking me out, but
Okay. All right.
made it.
Okay.
Sorry about that.
All right.
Okay, so we are now live streaming. So this is the inquiry of Allison Mullins, who sent in a request asking about her ability to sign and defense counsel's ability to include a confidentiality clause in a settlement agreement that she believes restricts her right to practice under Rule 5.6. The first thing I want to point out is that in the facts, I need to make a correction to the facts. There's a sentence, the second sentence about the trial court issuing extensive written summary, and then the last part of it and states and creates new law. And the trial court can't create new law, so I need to take that out. I'll get with Allison. I think there was a Court of Appeals opinion that was issued in this case that created the new law. At any rate, this was a tort action, a mid-mal case actually, where Allison Mullins represents the plaintiff. The case went through trial, went through up to the Court of Appeals. And as a result of the litigation, some new law was created. The parties, however, decided that they would mediate the value of the case for the plaintiff's damages, and they did that and settled the case. After the settlement, defense counsel prepared the settlement agreement, and it included rather extensive confidentiality language that prohibited the plaintiff and plaintiff's counsel from ever talking about this case, from using any information about this case for the lawyer. She couldn't use it for future representation. She couldn't speak about it publicly. And then, of course, the plaintiff could not speak about the settlement or the case at all publicly. Plaintiff's counsel thought that this interfered with her ability to represent future clients, and so she initially sought informal ethics advice from me about whether or not she could sign the agreement. I read the language in the agreement and I concluded that it did violate Rule 5.6 and she could not sign. I encouraged her to have defense counsel contact me, and so that I could explain to defense counsel why her language was not appropriate under Rule 5.6. She did that. There was a lot of back and forth and making changes in the language, but still, when all was said and done, there's still a lot of language in the agreement that violated Rule 5.6. So Allison asked if we could issue a formal opinion. So the opinion provides that based on Rule 5.6, lawyers cannot participate in or make any kind of agreement that restricts the lawyer's ability to represent clients or to practice law. Is that someone with a question? Okay. Relying on the rule, the opinion provides that a lawyer can disclose publicly available information in any public setting, but that any restrictions on any private information or information that was not publicly available, either through court hearings or any court decisions, any Court of Appeals opinions or anything like that, then the lawyer could disclose publicly available information, but was restricted from providing any private information. The opinion also relies on or points out that there are other rules that would be implicated by this confidentiality clause. Rule 3.3 requires that lawyers inform the court of any known case law, whether it's positive or negative for the client's, that lawyer's client's case, but you have a responsibility to make sure that the court is aware of any controlling legal authority. Rule 3.4 prohibits obstructing a party's access to evidence. So the fact that there might be a Court of Appeals decision out there, defense counsel could not prohibit plaintiff's counsel from using that information based on a confidentiality agreement. And then Rule 8.4D is the conduct prejudicial to the administration of justice, which is one of the catch-all rules that includes any kind of conduct that would impede a lawyer's ability to represent the client. One of the other basis for the opinion is that lawyers have to have the ability to represent clients, but more importantly, our rules are in place to make sure that clients and members of the public always have a choice of lawyer. And so a confidentiality agreement could not interfere with that. Clients need to, or the public needs to know, based on experience of a lawyer, cases that they have tried, information that they have obtained from representing other clients, that information would be useful in making a decision on whether or not to hire a particular lawyer based on that lawyer's experience. So the opinion does give some support under that. There are 3 ethics opinions, 1 from Alabama, and then 2 ABA opinions that come to the same conclusion. So that is, I think, a summary of the ethics opinion. So let me know if I can answer any questions for you.
Yeah, let me just follow up a little bit, Nicole, because Nicole and I talked yesterday, and this started out with some phone calls, and then I guess if you guys read the materials, you saw that it sort of morphed into 12 or more different questions, and Nicole has done a great job of condensing that down into the essential questions and facts. So great job, Nicole, of taking what was sometimes duplicative and bringing it into something that's digestible. So what I'd like to do is just kind of, before we start taking these inquiries one by one, let's just talk generally. I'm going to call on each one of you individually. And Tom, let's start with you. Just overall, the sort of 10,000 foot, your take on this.
Yeah, I think it would be an undue restriction on that attorney's ability to practice and to deny the public the attorney of their choice. I also mentioned at the last ethics committee meeting that the lawyer's duty to his current client is somewhat compromised. You're accepting a settlement in an area that you have invested a lot of time and a lot of money, perhaps engaged with many experts, and these are mass torts, so you're doing a lot of technical things. And I mean, of course, that lawyer has a duty to that client, but you're certainly putting him in a position where you're buying him out of this area of practice, and there's a lot invested there. And I think a lawyer is going to be tempted to put a price tag on that.
Right. Yeah.
So that's another one of my concerns.
Okay. Fran, 10,000 foot look at this. What do you think?
I mean, this information is already publicly available. I mean, that's kind of key to me. I've looked at all the rules. I'm, tried to play devil's advocate and find a way to, support why defense counsel could justify this, but I'm just not seeing it. And again, it's very key to me that we're talking about information that is publicly available.
Okay. Tara, you're muted.
Yeah, I'm sorry, they're fixing a door or something. That was the background noise earlier, but I agree with Fran. I think that what stood out to me the most is the tension it creates between the lawyer and their own client. Because if the client's like, yeah, this is a great deal, I want to sign it, and the lawyer has to be like, wait a minute, I'm looking out for my future career. I don't think we need to put any attorney in that position where there's just that unnecessary conflict between the lawyer and their own client. I mean, I think Nicole did such a great job laying it out, and I liked the Alabama opinion too. But I think that stress between the plaintiff's lawyer and their own client is what stood out to me as being the thing that could cause the most problems going forward.
Great. Kevin?
I would agree. I think she's done a wonderful job putting everything together there. I found it interesting because of how the parallels are with the heated discussions we recently had with the ability to convey commonly known knowledge or public information for CLEs and so forth. And this dives right into that, and I think protects what we ultimately landed on. So I think it's good.
Okay. All right. What and I agree. I agree that this is well written and synthesized and condensed. But I'd like to go over inquiries one by one and see if anybody's got any suggested wordsmithing or suggested additional language on anything. So inquiry one is straightforward. As part of a settlement agreement between private parties, may lawyer B restrict or otherwise limit lawyer's disclosure and or use of publicly available information concerning or stemming from the case, including court decisions and opinions. So Nicole has written 1, 2, 3, 4 long paragraphs with a footnote. And I'll give my opinion at the end, but I think she nails it. Tom, any suggested wordsmithing or modifications, additions?
I'm trying to pull that up. Okay, I've got the materials here. Can I pass for a moment? Let me look at this.
Okay.
Yeah, just can you pass over to Tara or Kevin?
Yeah. I'll start with Fran. She's the next one on my screen here. Fran.
Yeah, I echo that this was just very well written. When I was first reading it, Nicole, I'm like, wait, has this already been published? I mean, it looks good to go to me. I thought it was very well written, and nothing stood out to me as confusing. No, I don't have any concerns about it. I'll continue to look at it, but as I read it, I thought it was very well done.
Yeah, I think each paragraph, starts with the lead and takes on, Rule 5.B and then formal opinions and then ABA and Alabama and so forth. So I think the paragraphs are very well structured and logical and in order. Tara, any suggestions on wordsmithing?
No, I mean, I agree. When I was reading this, this is the first subcommittee I've ever been on, and I was making sure that I understood the procedure because I also thought that this was something we'd already put out. I mean, I agree. I think it's really well done. I didn't catch the thing about the trial courts, and now I feel like I should have read it better, but I think I don't have any notes just right off the bat.
Okay. Kevin? You're muted.
No additional pieces to add in reference to that one. No.
Okay. All right, Tom, back to you.
Does it address, was it Rule 1.8 duties to current clients? Do we have a?
Does not.
Now, Tara raised that. I did also. Is that something we want to maybe also include? Or does that
What
go beyond
part
the
of
scope?
1.8 are you concerned about?
1.8 is duty to current clients, right?
Well, it's a conflict rule. It's a hodgepodge of all the conflicts rules. So the first part is about business transactions, not soliciting funds from the client. I mean, not gifts from the client, financial assistance.
Yeah, and that's certainly that doesn't apply, but just duty to current clients and avoiding conflicts with the lawyers. Self-interest.
Under 1.7, like a personal interest conflict. Okay. Okay, I can work that in.
Yeah, I mean, I did say that too, and I wasn't putting those two together, but I'm trying to feel like if I was in that position and my client saying, you represent my interests, these are my interests. I do think something to protect the lawyer saying you cannot you cannot do this but I think all the other inquiries do that, but maybe something specifically addressing that rule could be helpful.
I think it's especially important these types because these are mass torts, class action cases. There is so much time invested; it becomes such a niche, and it's not just that lawyer. I mean, he has a whole team of paralegals, investigators, experts, other attorneys, interns. I mean, these are big operations, and I think you're really putting that lawyer in a tough spot. I mean, they're not able to, diversify from that point. They've made a career of that particular type of litigation, and it's very narrow.
Yep, I think the ABA opinion touches on
Yeah.
that too. Yep. So Nicole, you're gonna smith that in.
Yes, I'll figure out where to put that in
Okay.
opinion number one.
All righty. Anybody with anything else on inquiry number one? Let's go to number two, which is, are there any circumstances under which lawyer A may agree to a settlement of a client's claim that restricts lawyers A's ability to use or disclose information concerning the case? And the answer to that is yes. And this talks about, publicly available information. And once again, this is 1, 2, 3 paragraphs that are, I think, well laid out and well structured. So let's talk about number two. And Tom, I'll come to you last. I'll start with Tara.
Okay.
I don't think I would change or add anything to this. I think it's very clear. I mean, I mainly do criminal defense. I have worked on some civil cases, but I mean, even for me, I think of myself as like, okay, if I was a beginner coming into this and I just really needed some guidance straight away, I think that provides that guidance very, very clearly.
Kevin?
I agree. I think it's well written as is.
Okay. Fran?
Same. I mean, it just really, bugs me that they're trying to restrict access to publicly available information. I mean, that just really annoys me. So what she's written there is what I thought confidentiality agreements were about, was just, restricting the amounts and, the confidential terms. So again, great work, Nicole.
Thank you.
All right. Tom, you got another rule to pull out of the hat?
No, I don't think I can improve upon that. I think, I'm surprised. To me, it was a no-brainer. You can't do this. So I'm glad that Nicole's language is very pointed and clear, and there should be no ambiguity after this.
Yep. Okay. Yeah, that's and I think that's consistent with everything that's gone before the ABA and the Alabama and consistent with the rules. All right. Now this goes into what we were talking about earlier about inquiry number 3, about the right to practice under Rule 5.B and how that's impacted. And so the question, and I'll just summarize here, would a restriction in a private settlement agreement seeking to prevent lawyer A from including the case in any updates on legal development to members of the bar infringe on the right to practice? And there's really 2 questions in there, but Nicole answers them in a 2-sentence answer, yes, or 3-sentence, yes and yes, and see opinion number 1. So it's pretty straightforward. Tara, I'll start with you. Anything you want to add, modify?
No, I think it's I also thought this was a no-brainer beforehand. I mean, I think it's just integral to our profession that we be able to share, not as dollar amounts, not things like that, but experiences from prior similar cases. I think it doesn't need to be any longer.
Okay, great. Kevin?
I agree. I like the fact that it's short and simple and kind of goes with that no-brainer.
Yeah, Fran?
I agree. I feel like somebody said earlier, we already discussed this recently in Raleigh. I can remember sitting in that room, I thought, having a discussion about this. Plus, if you prohibit a lawyer's right to share war stories, we're going to have unhappy lawyers all over the state of North Carolina. But yeah, I think it's fine the way she's written it.
Yeah, we kind of fixed that with 1.9 modifications. So it really, I think, moves it along. Tom, anything to add?
No, I mean, just, this kind of conduct is not just hampering one lawyer, but it has an effect on the entire bar if they're You can't talk to other attorneys about their experience. They can't go to a law school and act as an adjunct and teach a class and talk about what they've done. I mean, it just has widespread consequences. It's not fair at all. It violates First Amendment. It violates
that's
any good sense.
the First Amendment stuff is really not in the orbit of the state bar. That's in the courts. We're rules and rules of professional responsibility. So, but you're right. It certainly would open up the state bar to being litigated against in court on First Amendment grounds, like happened in Virginia with Rule 1.6. All right, number 4, and this sort of kind of pulls it all together. Are there any other rules that prevent a lawyer from insisting on or agreeing to provisions in a private settlement agreement that would inhibit the lawyer from being able to fully disclose and discuss publicly filed and maybe we should say publicly available court decisions in a case or to a court in the future? And Nicole has once again a 1-paragraph answer, yes, and then she lays out 3.3, 3.3a, 3.4, 8.4, and we've already talked about 5.6 because the question is, are there any other rules? And so
maybe this is where I can put the 1.7.
Yes.
Instead of a number 1.
I was getting ready to suggest that. So, yep. And Nicole and I talked briefly yesterday about, the modifications that have been approved by the Supreme Court to Rule 1.9. And the two of us thought that since that's really straightforward and talks about former clients and not present clients, that it really doesn't need to go in this opinion. But if anybody's got some other thoughts on that, I'm open to that. Let's first talk about the answer to number 4 about the other rules. Tara, what got any suggestions, modifications, additions, subtractions?
You just mentioned that publicly available does cover publicly filed. So I think in the inquiry itself, you could cut publicly filed and just leave it as discuss publicly available court decisions. And I feel like that blanket, it just could cut out. I don't really think it's confusing, but it could cut out any possible confusion. But I don't have any other than that. I think the opinion itself is great.
Okay. Kevin?
I would agree. Nothing else to add. I know you already mentioned that 1.7 part to go in there, but
yeah,
that's it.
Yeah. Fran?
Nothing to add.
All right. And Tom?
Nothing to add. I'm glad that 1.7 can somehow find its way in the opinion, even if it's
that's a perfect spot for it. So basically, kind of let me wrap this up with, we sort of got consensus on this, that we're going to be taking out the sentence in the preamble here about the trial court being able to make new law. And then we're going to add the 1.7 on opinion number 4, and maybe put the word publicly in one other place. But does that basically summarize where we are? Nicole, does that summarize where we are?
Yes.
All right.
Well, I've got that. And what I'll do is I'll make those changes. I'll email it to you, and then reply to me individually with your thoughts. Don't do reply all, because if you hit reply all, then that's another meeting and we have to notice that. So if you just respond to me individually with any comments or changes that you want, that'd be good. And I'll prepare the subcommittee report and send that on to you, Evan.
Yes. So the recommendation is going to be, and let me just put this out there, the recommendation will be that the ethics committee vote to publish this and then wait for comments. Is that where we are once we get this done? Yes. And what I'll do is when, Catherine Fry is going to be chairman of the ethics committee this next year. So when she calls on me, I'll I'll ask each one of you if you've got something to add to it, okay? And to the whole committee. All right. Well, thank you all,
I
and
think just
good luck.
we're incorporating 1.7 and 1.9, where those are the two rules
No,
that,
no, we're not incorporating 1.9. It really
Okay.
doesn't fit. It doesn't fit.
okay, 1.7.
Yeah,
Right,
because
just 1.7.
these are present clients. This is not former clients. So,
Okay.
yep. So, all right. Well, I hope
Thank
you get
you
your
all.
power back, Tom, and Tara. You can go back to district court. Kevin, you can, and Fran, you can go back to whatever you were doing. And Nicole, thanks.
Okay, no
Thank
problem.
you.
Thank you all.
Great
I'll
work,
say-
Nicole. Thank you.